Welcome, everybody. It's great that you're joining us today at the 20th LSE German Symposium 2021 for our third and last official event on this Wednesday, but definitely not the least interesting one. That's something I can promise you because our speaker now is Philipp Amthor, member of the German Bundestag. Thank you very much for joining us the second year in a row at the LSE German Symposium. Mr. Amthor was elected member of the German Bundestag in 2017 with the age of 24 and has since then become famous for his public speeches about law and politics. Now, we would like to hear more from him about this topic. Who governs in terms of crisis? Constitutional expectations and constitutional realities. This keynote will be shared by Maurice Hirt, the president of the German Society of the London School of Economics and Political Science. I would now like to hand over to you, Maurice, and I wish all of you an intriguing debate.
Thank you, Vanessa, for the introduction, and thank you all for joining us this afternoon. It is exactly 1 year ago that we were sitting together in the LSE Old Theatre to discuss far-right populism in Germany and how mainstream parties have to adjust their approaches to politics in the age of social media. Today, Philipp Amthor, will again take a step back from the business of daily politics and offer us a German insight into a topic of international relevance. Who governs in times of crisis? 12 months ago, a discussion of the role of parliament and the executive would have been a very abstract one. But I think this year we have all learned a lot about our institutions and our basic rights. So today we will surely add something to this knowledge. And so please, Philipp Amthor, the floor is yours.
Thank you very much, Maurice. Ladies and gentlemen, thank you very much for inviting me to the 20th German Symposium of the London School of Economics. I'm delighted to be able to address you again in these turbulent times as part of this well-known and established series of lectures. New beginnings, that is your theme this year. An optimistic title, focusing attention on how we can initiate new beginnings during and after the crisis. To learn lessons from any crisis, it is essential to reflect on the factors that are at play in a crisis. And I would like to engage in this reflection with you today by exploring the following topic from the perspective of constitutional legal theory as well as practical politics. Who governs in times of crisis? Constitutional expectations and constitutional realities. For those with a less passionate interest in constitutional law, of course, there is an easy response to the question, who governs in times of crisis? The answer is easy, the government. But since you are not an average audience, but highly interested academics, and since I am a member of the Bundestag with a responsibility for constitutional law within my CDU-CSU parliamentary group, I intend to seek a somewhat more multidimensional answer to that question. Of course, the government governs in times of crisis too, but the basic law of the Federal Republic of Germany, our Grundgesetz, or let me say for this purpose, our German constitution, always assigns a share of competence to parliament in both normal and critical times for running the country. But to what extent has parliament exercised this power of co-governance? And what lessons can be learned from that for the future? And has parliament as a whole matched the functional expectations of the constitution during the COVID crisis? To answer these questions, I would like to reflect in the first part of my lecture on the development of the state's effort to combat the pandemic, to establish and assemble the facts as it were, and to validate the hypothesis that the hour of the executive strikes in times of crisis. In the second part, the main part, I would then like us to compare the abstract expectations of the Constitution in terms of some parliamentary functions with a constitutional reality. Ladies and gentlemen, to the first part. When the state's efforts to combat the pandemic have been described in the media and the general political debate, references has often been made to the so-called hour of the executive, striking in times of crisis. And so, in the eyes of many observers, the fight against the pandemic was regarded as primarily a matter for the federal and Länder executives, while the role devolving on the Bundestag and the land parliaments seemed to be largely that of an uninvited spectator, an impression that can be traced back to, in my eyes, 4 factors. First, the preconditioning by the Conference of Minister Presidents of the Länder with the Federal Chancellor is undoubtedly a key factor for this impression. These informal deliberations between the Chancellor and the 16 Minister Presidents are not institutionalized in the provisions of our constitutions, but have been part and parcel of governmental practice for many years. On account of their discussions on measures to contain the coronavirus pandemic, they have in fact been perceived by the public as the real hub of political decision-making. Although these informal meetings have had no genuine legislative power, their outcome had often been the de facto political precondition for decisions establishing rules relating to public conduct, such as face covering requirements and social distancing rules, on the need for and the nature of lockdowns with quarantine rules and contact restrictions, and on the economic life. The public announcement of these decisions has been made by government representatives at the press conferences immediately after the discussions, and only later, or so it has seemed, been analyzed in the parliaments. The noticeable restrictions of people's fundamental rights, such as their general freedom of action, their freedom of assembly, and their freedom of practice their religion, trade, or profession, have initially been announced by the government. The second factor, the second aspect of this perception of an hour of executive were the executive announcements of economic assistance. Government representatives not only announced the bitter medicine, but also the sweet grapes of economic assistance. So the Federal Minister of Finance wanted to combat the pandemic with a budgetary bazooka, as he put it. It was government representatives who announced the provision of billions of euros in aid for businesses, as in the case of the coronavirus mitigation package in March 2020. Short-time working allowance scheme, fiscal liquidity support measures for businesses, a large-scale program for state guarantees, and so on. The same applied in June 2020 and again in the winter months with several bridging aid programs. So Parliament authorized these budgets and itemized them thereafter, but the government was a bearer of the good tidings. The third point, announcing restrictions or aid measures during the pandemic, however, was not only the role of governments. They also had the task of implementing those decisions. And this leads to the third point of the perception of an hour of the executive. The respective constitutional norm for the implementation of federal parliamentary legislation states that the Länder execute even federal laws in their own right. This applies particularly to anti-infection legislation. For example, the Protection Against Infection Act, or Infektionsschutzgesetz in Germany, as a federal act of parliament. But although it was passed by the federal legislature, the Bundestag and the Bundesrat, its provisions have been fleshed out in more detail by the constitutional organs of the Länder and are implemented by their executive organs. So, although the federal legislature created the abstract framework for pandemic-related restrictions of freedom, it is often the COVID regulations and COVID orders of the Länder with their concrete do's and don'ts that seem to be more interesting and more relevant, the focal points of public and media discussions because of their immediate impact on people's everyday life. And all of this was compounded, especially at the start of the pandemic, and this is the fourth factor I want to describe, by the impression provided even by some of its own members that the parliament, with its sometimes lengthy procedures, seemed at first sight to be too ponderous to respond instantly to crisis. Consequently, the initial debates, instead of focusing on the legal principles relating to infection control or on conditions imposed by parliamentary legislation, were actually dominated by a struggle to ensure that Parliament itself could function efficiently and act effectively. Although it proved possible to maintain the essential effectiveness of Parliament at every point in the crisis by means of cross-party arrangements, health protection rules, and amendments to the rules of procedure, this public questioning, which was necessary at the time, contrasted with the constant activity and crisis management of the executive organs. So, to sum up this first part, once these four factors have been considered, the reasoning about the hour of the executive is not surprising, because in the public mind, it is not the Bundestag, but rather the Federal Chancellery as venue for meetings between the federal government and the minister presidents, which is perceived as the place where the relevant decisions are being taken. Accordingly, in both the political and the constitutional debate, the question has rightly arisen as to whether is this supposed hour of the executive parliament has been downgraded or has downgraded itself to an uninvited spectator role that contrasts all too sharply to its expected constitutional role. Ladies and gentlemen, this hypothesis that the hour of the executive strikes in times of crisis can be subjected to particular robust scrutiny in the light of the constitutional order if we turn our attention, as I intended to do in the following main part, to constitutional expectations regarding the function of Parliament and compare it with the constitutional reality during the present crisis. To this end, three questions have to be asked. First of all, to prepare the ground, there is a long-established abstract question of who is sovereign in a state of exception. And then come to the second and third question, which are concrete in nature, namely whether and to what extent the Bundestag has adequately performed its legitimizing function and its governing function during the fight against the COVID pandemic. Ladies and gentlemen, any academic reflection on the hour of the executive hypothesis leads sooner or later to an old familiar question of constitutional theory. Who is sovereign in times of crisis? In our German constitutional tradition, this question was raised with particular clarity back in the days of the Weimar Republic in what is both a famous and an infamous statement made by the famous constitutional theorist Carl Schmitt, who said, "Sovereign is who decides on the exception." The exception referred to in this question is often associated and first and foremost with the notion that exceptional situations justify exceptional measures, even constitutional measures. A hypothesis one could hear in political debates during the coronavirus pandemic too. Although this has frequently been expressed as a general political cliché rather than an awareness of all the constitutional implications, it must not be forgotten that today's response from the German constitution to this hypothesis always has to be different from the response made by Carl Schmitt almost 100 years ago. Schmitt's theory saw the state of exception as a situation in which it was necessary and justifiable to loosen or suspend legal ties and to authorize the enactment of measures by which the legal order could be breached, supposedly for the purpose of protecting or restoring the legal order, which ultimately boiled down in practice to an executive dictatorship in a state of exception. It should be recalled that the Nazis used this theory for their own cruel purposes. Knowing this, our German constitution delivers a clear answer. The constitution itself is a non-negotiable yardstick of state authority and remains so even in times of crisis. So, the authors of the German Basic Law knew that the rule of law, the foundations of which are protected by the Eternity Clause enshrined in Article 79, Section 3 of the Basic Law, read in conjunction with Article 20, would lose its limiting function in exceptional times if it were framed with a view to protecting the legal order by temporarily suspending it. Such tolerance of constitutional illegality would too easily give rise to the danger of misinterpretation in the sense of necessity knows no law. Furthermore, the Constitution provides a quite different response to a state of exception. 4 short points. First, the sovereignty in times of exception lies in exactly the same hands as it does in normal conditions. It lies with the people. Article 20, Section 2 of the Constitution proclaims that all state authority is derived from the people. Every action on the part of the executive must therefore be legitimized by the people and be traceable to a relevant legitimizing link. Second, a state of exception does not trigger an automatic relaxation of subjection to the rule of law. The rule of law is prescribed by the German Constitution and must never degenerate into a situation of lawlessness, not even in emergencies. And even in the fragmentary clauses of the Constitution concerning a state of emergency, the authors of the Basic Law, acting very deliberately in the light of historical experience under the Nazi dictatorship, did not provide for a concentration of power with exceptional rights in the hands of a single state authority, for any general emergency powers, and not for any dispensation for the executive to enact emergency legislation. Even in the special circumstances of a state of defense, the Basic Law does not provide for unilateral executive action, but for a kind of a condensed emergency parliament, which comprises members of the Bundestag and the Bundesrat and ensures that parliamentary responsibility is exercised in exceptional times too. And this leads me to the third point. The constitutional expectation is that the functions of the parliament in times of crisis are not different from regular times. At the start of the pandemic, concerns that the parliament might lose some of its ability to function, it was discussed to establish a constitutional amendment for an emergency parliament for epidemics. But shortly after the first informal discussions with the parliamentary groups, this idea was rejected by a majority as inexpedient. The Germans' historical rooted skepticism about emergency constitutional arrangements will surely have been a factor for this. And last but not least, as a fourth but clear point, the existence of a crisis does not release the state from its duty to protect fundamental rights of its citizens. The weighing of fundamental rights is essential in times of the crisis. And to sum up these 4 points, necessity knows no law or no parliament is not the answer of the German Constitution. Ladies and gentlemen, let me, knowing this, focus on the legitimizing function of the parliament. The parliament is the key intermediary and source of democratic legitimization for all other organs of the states. And as a rule, the executive authority can only encroach on citizens' fundamental rights through or on basis of a legitimizing parliamentary decision. I should now like to explore with you whether and what extent Parliament has met this expectation in the constitutional reality of the COVID crisis. Our starting point here is the Act of Parliament, the main instrument through which parliaments let legitimacy to the executive, being the direct expression of the will of the representative organ directly elected by the people. Under Article 20, Section 3 of the Basic Law, all state authority is bound by the law, established in this way and by justice. And legislation, for its part, is always required as a rule whenever the state intends to encroach on people's fundamental rights. Restrictions on fundamental rights, such as the requirements and prohibitions in the coronavirus pandemic, are subject to the proviso of legality. In Germany, we call this Vorbehalt des Gesetzes, which means no legitimate restriction of freedom without act of parliament. Needless to say, this principle does not go so far as to require that all of the conditions for each and every restriction of fundamental rights must already be set out in full detail in the Act of Parliament itself. In fact, there are many cases in which Parliament is largely at liberty to legislate by means of open-ended blanket clauses and delegate to the executive the right to flesh out provisions and balance interests. This can be done in particular by means of acts of parliament, which authorize the executive to enact statutory instruments. This model of executive lawmaking authorized by an act of parliament is most often adopted in constellations in which the parliament wishes to enable the executive to act and react more responsively and swiftly than the frequently complex parliamentary procedures would otherwise permit. The Infektionsschutzgesetz, the Protection Against Infection Act, is a prime example for this. In its sections 28 to 31, the parliament imposes conditions governing measures taken by the public protection authorities, but section 32 empowers the government of the Länder to formulate precise do's and don'ts. And this leads us to the core of the constitutional law debate of this complex. What are the constitutional limits of Parliament's delegation of legislative power to the executive? To be frank, these limits are only more or less clear. The Federal Constitutional Court of Germany established, therefore, the so-called theory of the proviso of essentiality. In Germany, we call it Wesentlichkeitstheorie. Following this theory, the Parliament is required to take all essential decisions in area of basic normative legislation itself, especially in matters pertaining to fundamental rights. The crunch question of this theory is obvious. How on earth do we define these essential decisions that Parliament must take itself? There is a nice little witticism among German constitutional lawyers that goes like this. Essential according to the theory of essentiality is what the Federal Constitutional Court finds essential. So it's not clear in every case. But joking aside, a crucial point for our lecture here is the following. The more severe and intrusive the restrictions on fundamental rights of the citizens are, the more essential it is for Parliament itself to enact the legal basis for such restrictions, and the more detailed and timely that legal basis must be. Let us turn now to the concrete question. Has the Parliament made the essential decisions during the corona crisis? As I mentioned before, the executive organs of the Federation and the Länder have based their various pandemic-related measures, such as compulsory face covering, social distancing rules, quarantine rules, and contact restrictions, on the legal basis of an Act of Parliament. The Protection Against Infection Act, das Infektionsschutzgesetz, which already existed before the crisis and which authorizes those executive organs to enact statutory instruments. This soon aroused criticism, especially in academic circles, which feared that a massive and prolonged shutdown of public life could not be based on a blanket clause which 16 land governments and their authorities were essentially left to flesh out. This issue has fairly soon also concerned the courts, because many citizens exercised their constitutional right to request a judicial review of the pandemic control measures. In the initial phase of the pandemic, the bulk of the legal measures taken by the Länder seem to have been approved, mostly by the lower administrative courts in summary proceedings, and no judicial objections were raised in the light of the theory of essentiality and to the constant measures. The courts acknowledged that the scope of the required safeguards could not possibly have been adequately foreseen or determined in advance by the legislator. But as the pandemic continued, however, more and more courts began to question more control measures on the ground that the Protection Against Infection Act no longer provided the necessary legal basis for restrictions on fundamental rights. To put it short, the courts were no longer prepared to let the executive continue doing what it had initially been authorized to do on a shaky legal basis if the Bundestag left the legal basis shaky. In view of the duration and severity of the measures and also to prevent defeats in court, it was therefore necessary to clarify the Protection Against Infection Act by means of parliamentary legislation. To that end, in the course of the COVID pandemic, the Bundestag has in particular amended and supplemented the provisions of the Protection Against Infection Act in a total of 3 population protection acts. I do not intend to examine all the details here, but I would like to look briefly at some main amendments which will essential decision-making of the Parliament. To the first, the adoption of a criteria of so-called epidemic of national proportions, which was declared by the Bundestag in March for the first time and most recently reaffirmed by Parliament on November 2020, is a very important political proviso imposed by Parliament, because it ensures that numerous pandemic control measures cannot be ordered by the executive unless Parliament has declared such epidemic situation. Restrictions on fundamental rights, such as stay-at-home requirements, contact restrictions, social distancing, and face covering requirements, were explicitly catalogued in a newly created provision. These measures are not all automatically warranted by the proclamation of an epidemic of national proportions, but must be balanced in each individual case against the fundamental rights of the people. Parliament underlined, in the event of an epidemic, as declared by the Bundestag in the case of COVID-19, the catalogued measures are at least abstractly feasible in the eyes of the legislator. And on the question of the criteria governing restrictions on freedom, Parliament has clearly laid down that the main criterion for the implementation of control measures and for the balancing of fundamental rights is the number of new cases of coronavirus infection per 100,000 inhabitants within specified regions in a 7-day period. This is known as a 7-day case rate in Germany. In this way, Parliament has made clear that it expects the executive to manage the pandemic by means of a graduated regional approach. And finally, Parliament imposed a new requirement relating to the temporal limitation and justification of all measures taken under the statutory instruments enacted by land governments. Hereto, the Parliament clearly expressed that it expects land governments to keep assessing their pandemic management and to review their decisions every 4 weeks in principle. In sum, these requirements, namely, first, the catalogue of measures, second, the regional differentiation of measures, third, the new justification and time limitation criteria, demonstrate particularly clearly the governing of the government by the Parliament. Though it has sometimes been driven, I still believe that the Bundestag itself took the key decisions establishing the framework for actions under the Protection Against Infection Act. It has thus satisfied the requirements of the theory of essentiality, a fact that is also being confirmed incidentally in current court decisions. Parliament has been the scene of the essential decisions, even if it was maybe not always fully aware of this fact. And ladies and gentlemen, at the start of my lecture, I asked the question, who governs? I provided a simplified answer. It's primarily the government that governs, whether in normal times or in crisis. But the Constitution also assigns a permanent share of governmental power to Parliament, even in times of crisis. Let me, slowly coming to the end of this lecture, explain this function in more detail by reference to the exercise of budgetary rights and to the steering of legislation by the opposition and of the governing coalition in the Bundestag. Let us look on the budgetary powers of Parliament, frequently referred to in Germany as the Königsrecht or royal prerogative of the Parliament. It makes a very important contribution to parliamentary efforts to steer the government, since all items of state revenue and expenditure must be entered in a federal budget, which is then adopted by the Bundestag. This also applies in times of crisis. In other words, Parliament would have been able to throttle down government activity at key stages in the pandemics by applying the lever of its budgetary powers, or could at least have used that political negotiation power to steer it in a different political direction. Let us look at some trends. The original expenditure estimated in the federal budget for 2020 amounted to about 360 billion euros. Because of the pandemic, this sum was increased through supplementary budgets by about 146 billion euros in March and in July 2020. These additional sums were intended to create crisis response and recovery packages to cushion the social and economic effects of the pandemic on people's lives. These measures have not always taken the form of public expenditure, but also include reductions of public revenue. As a result of the pandemic response programs, the expenditure estimated for 2020 at the end of that fiscal year, it exceeded 500 billion euros. To refinance this amount, plans had to be made to borrow about 280 billion euros in the financial markets. And let me say, Parliament therefore had to vote by an absolute majority of its members to declare a so-called unusual emergency situation to overcome the normal obstacle of the constitutional enshrined debt brake. The federal budget for 2021, which was adopted at the end of 2020, remained influenced by the financial challenges of the coronavirus pandemic, and consequently provides for federal expenditure of about 499 billion euros in 2021 and a borrowing requirement of some 180 billion euros. The big governance-related question concerning these figures is self-evident, namely to what extent did these budgets authorized by Parliament reflect the original wishes of the government, and to what extent were the government proposals amended by Parliament? The answer will probably surprise many of our younger generation in particular, given the heavy future burden created by these borrowing requirements. Parliament actually went beyond the government's budget proposal in 2021 by authorizing additional expenditure of some 85 billion euros, as well as corresponding additional loans amounting to around 84 billion euros. These adjustments, regardless of their fiscal rationality, certainly became necessary in the course of the parliamentary process because the scale of the pandemic had increased dramatically again between the time of the government draft and the parliamentary decisions on the budget. But one point was really clear concerning these adjustments. They were not only based on governmental arguments, but also on a conscious parliamentary examination as a result of detailed parliamentary discussions. In sum, at all times during the pandemic, Parliament knew and this is my personal experience too, that the government's COVID assistance measures could have not been put in place if they had represented only the will of the government, and that they always needed parliamentary consent. And now, ladies and gentlemen, at the very point covering the governmental function of the parliament in the crisis, we have to ask us the question, how far did the parliament participate in the governance of the state during the COVID pandemic by steering non-budgetary legislative initiatives of the government? I have already mentioned the changes during the legislation process of the Population Protecting Act, but I want to move also to concrete observations. The first dilemma for Parliament in this context lies in the difference between the role of the parliamentary opposition and that of the parliamentary groups in the governing coalition. While the former have a natural interest in amending government bills, but have no majority to do so, the latter generally have the majority required for highly significant amendments, but usually have little political interest in doing so out of considerations for the government. The consequence of this constellation is normally the phenomenon that the opposition often table amendments which are primarily designed to attract media attention and which are only ever considered by the government in absolutely exceptional cases, while on the other hand, the governing groups, for their part, are often anxious to clear up any disagreement between the government and the coalition groups before proposals see the light of day in the parliamentary process. Both sides have run into additional programs during the coronavirus pandemic. For the opposition has tended to be less interest in airing their objections too vehemently in public, because in times of crisis, action is supposedly more appreciated by voters, and because all of the opposition parties, except the AfD, but thanks God, are in governing coalitions in several länder and therefore participate through their representative land governments in the Conference of Minister Presidents in the Federal Chancellery. They are thus involved in the COVID management that their party colleagues in the Bundestag might otherwise have criticized. But the parliamentary groups of the governing coalitions have been faced with a problem too. The time in which parliamentary groups and the government could consult at leisure and iron out any differences before the official start of a parliamentary process is no longer available, because suddenly, due to the pandemic, there is a huge pressure to act swiftly, which has very certainly had an adverse impact on the effective steering of legislation by the groups of the governing coalition. These steering obstacles, and I must be honest with you here, have had an effect on constitutional reality, especially in the first phase of the pandemic. Parliament was sometimes all too dividend, watching and hoping for formulation guidance from the government and its ministerial apparatus. And in the early stages, it often tended to make only marginal modifications to government proposals. Beside the factors I have already mentioned, there was no doubt, due to the pandemic-related restrictions which Parliament had imposed on its own everyday activity and which were reasonable and perhaps even largely necessary from the perspective of health protection. It is not surprising that more rapid procedures, shorter debates, mostly with only a few members present, and with video conferences instead of informal preparatory discussion sessions, were not exactly a recipe for a highly influential parliament. Fortunately, however, in the further course of the pandemic, the Bundestag managed to effect a return to a more self-assured form of parliamentarism. In this matter, I want to name a very clear contribution to a debate by the chair of my parliamentary group, Ralf Brinkhaus, who, together with his SPD counterpart, acts as a parliamentary leader of the parliamentary majority in the governing coalition. Without beating about the bush, he addressed the Federal Chancellor directly following her government policy statement, criticizing her and the Conference of Minister Presidents in autumn 2020 for not having involved the Parliament sufficiently in the joint decision of the Federation and the Länder. In that respect, Ralf Brinkhaus, in my experience, injected a fresh liberating momentum into public domain. This momentum of the Brinkhaus speech, however, did not come out of the blue. It was also part of a trend. In the period from mid-March to end of October, the plenary chamber of the Bundestag addressed the coronavirus pandemic in more than 70 times and passed around 30 related laws. But not only in speeches, but also in substantive legislation amendments, it became increasingly evident within the parliamentary process that the enduring dictum of former SPD chairman Peter Struck, that no law ever exits Parliament in the same form in which it entered, was gaining validity again also during the corona crisis. The most striking example for this is surely the Third Population Protection Act, which I already mentioned before. Accordingly, I would draw a mixed conclusion regarding the governance and government function of Parliament in the COVID crisis. After perhaps excessive initial restraint, the Bundestag found its way back to a more self-assured practice of parliamentarism. Ladies and gentlemen, I thank you for your long listening, and I want to conclude with one last thought. We must be aware that the concerns I have outlined about an increasing primacy of the executive in the parliamentary system of government and about deparliamentarization is older and more deeply rooted than the pandemic itself. Questions of deparliamentarization shall not only occupy us in times of crisis, but in normal times too, whatever normal times may be. But the deparliamentarization of parliamentary systems of governments is undoubtedly a constant danger for which self-assured parliamentarians and true friends of parliamentarism are needed. I hope that I have been able to enlist you in these ranks today. It would delight me if in future, when you ask the question, who governs in times of crisis, you would join me in giving the right answer, which is the government, of course, but always the parliament too. Our state is jointly entrusted to both in times of crisis and in normal times. Thank you very much.
Thank you, Philipp, for giving us a lot of material to think, and I'm sure finishing with Ralf Brinkhaus, he will be delighted to hear your endorsement when he addresses us tomorrow. But I would like to get back to your conclusion. You have mentioned the excessive initial restraint of Parliament, and there it was the judiciary, not Parliament, which sets the constraints to the power of the executive. To what extent do you think has the judiciary, as particularly in the early stages of the pandemic, shown a greater power of enforcement of the sovereignty of the people and to uphold the rights of in the basic law of Germany?
Yeah, Maurice, you address a really valid point, because in my analysis, you probably also recognized the courts were very important by driving the discussion or to drive the discussion in the parliament. And of course, the courts were in the early decisions in the first phase of the pandemic not so straight with us regarding especially the constitutional law. This has mainly two factors. The problem is, if a normal citizen goes to a court against one of the measures of the Länder executives, he doesn't start at the Federal Constitutional Court, he starts at one of the lower administrative courts. And of course, from a sociologic perspective, it's not so easy for a judge at a lower administrative court, for example, in a small town at the beginning of his career, to say this legislation is against the constitution. This is a really typical phenomenon. So it's mainly typical that at the lower administrative courts, the issues or the problems of a conflict with the constitution are not so popular. This is one factor. And the other factor is, of course, that the situation of the coronavirus, the situation of the pandemic, was new not only for the executive, not only new for us as legislator, but also for the judges. So they were definitely more open to say, okay, we are also not sure what's the right interpretation of this or of that measure. But with a continuing time, of course, there was more evidence in the public discussion, in the academia, on the health sector, also in the public discussion of well-known constitutional law theorists in Germany. And this affects also the courts. And to be really frank with you, I think these big changes in the Infektionsschutzgesetz we have made as parliament, they were only possible because the government was frightened to lose more and more proceedings in front of the courts.
Thank you. Another aspect of government, you have primarily addressed the horizontal balance of power, but you have also mentioned the centrality of the states in guiding and executing legislative acts from the federal level. So on Monday, we have heard from Minister Karliczek, who has drawn conclusions from the COVID crisis on federalism, particularly for her department. What do you think is the key conclusion we have to draw from the COVID crisis on how states and the federal level are interacting?
To be honest, from my point of view, the corona pandemic proved that the federalism in Germany is in a good situation at all, because the conference of the minister presidents with the chancellor, I also criticized it a little bit from the perspective of the parliament on the federal level. These conferences showed that the federalism all in all worked. And one key idea of the federalism in Germany is also an element of competition between the Länder. And so it was not on a not acceptable level, but at the first phase of the pandemic, of course, we had the discussions in the conference of the prime ministers of the Länder, but we also had a kind of trial and error in the different lands. So North Rhine-Westphalia practiced other plans in the fight against pandemic than in Bavaria, and it were only small differences. But I think this shows that the federalism in Germany is all in all working. And I think the bigger problems are, if we look at the problem of the separation of powers and checks and balances, it's more a problem on the horizontal level than on the vertical level you mentioned. But of course, also, there is one problem that we must look, definitely the problem that the Länder execute all legislation from the federal level leads to problems, of course, if there are some problems in executing them very well. For example, with the economic aids, we have this problem with this bridging aids at the moment. They were called November and December aids, and now we have the beginning of February, and they are not executed now. In fact, and this is also a problem where we on the federal level could not execute as easy as we probably wish sometimes.
Yeah, thank you for these comments. I think particularly the economic aid is an issue that many people in Germany are still criticizing. But before I hand over to the audience and their question, I have one last question. So you mentioned as well in your speech that the Bundestag and the Ältestenrat and all the parliamentary groups have dismissed quite early moving towards an emergency committee, as it is the case for acts when there's a state of defense and the Verteidigungsfall. But now Schleswig-Holstein wants to introduce that kind of committee, which has been also criticized by many legal scholars. What is your opinion on using the kind of emergency committees during COVID, or are there any other means that are better to exercise these legislative acts?
Yeah, as parliamentarian that had a really high expectation on parliamentarism, I mentioned, I am also more skeptical with this idea in Schleswig-Holstein, because we must be really frank in this discussion. Every legislation or every amendment of constitutions that leads to a various parliament, to a parliament in this problem cases, is a weakening of the parliament itself. And regarding all the problems that I have mentioned in the relationship between government and parliament, this situation increases a deparliamentarization, and therefore I think the parliaments have the duty to show that they are functioning and that they could take all their functions also in times of crisis. So I'm really skeptical about all these constitutional amendments that lead into a crisis situation for parliaments. We must avoid this. This should be the goal of parliamentarians, I guess. And therefore, I think also the state parliament in Schleswig-Holstein showed and proved that it is able to work without this constitutional amendment, but it's their sovereign decision to talk about their constitution in Schleswig-Holstein as they might think it's possible, but I think we should be skeptical with such ideas.
Thank you. We will now go over to questions from the audience. We have a lot of them coming in, but if you want to ask more, you can always do that through the question answer tag. So the first one comes from one of my former classmates. I just see that. Do you think that the COVID pandemic will impact how citizens judge the actions of different political parties and parliamentary accountability at the ballots in September? And yes, in what ways? So that's the first question from our audience.
Yeah, I would say I hope so a little bit, especially if we look at the far-right populists from the Alternative für Deutschland, if we look at the AfD. I think these times of crisis showed so clearly that they are not able to make politics that are responsible for the needs of the people. And this is a situation where they delegitimize the institutions of the state. And so therefore, I hope personally, because in my constituency in Mecklenburg-Vorpommern, my main enemy is, of course, the AfD. They were on the second rank last election, on the second place. And therefore, I hope, of course, that the people understand and that the voters understand that far-right populism couldn't help in times of crisis. This regarding the AfD. But looking at my own party, looking at the CDU, of course, I also think that the situation and the question how effectively and how successful we manage the pandemic affects our result at the elections in September. If we look at the last months, of course, it was an advantage for the governing parties. Times of crisis are sometimes in the question of how popular parties are an advantage for parties. But this advantage could really quick turn into a disadvantage if some things wouldn't or didn't go well. You've managed the example that I already mentioned too, the question of economic aids. there is, of course, also the problem of base science and the problem how we deal with this crisis. And if we are not able to reduce the COVID rate in Germany, and if we are in the need to be much more longer in this lockdown situation, of course, this also affects the result of the CDU. So it is in the interest of our country, it is in the interest of our own party to manage this election and to manage this problem with the good and right answers.
Yeah, thank you. And I think in the US, it has also shown how the pandemic management will impact election results.
Definitely.
Yeah, but the next question comes from Lukas Boden, LSE student from Frankfurt, who also addresses some of the points you have raised. The current crisis warranted wide-reaching restrictions on basic rights. Now that vaccination efforts have begun, what is your opinion on lifting these restrictions for people who have received both vaccination dosages?
Yeah, I think from the perspective of our constitution, it is necessary to ask at every restriction on fundamental rights whether there is a good reason for it. And this is also valid in the times when vaccinations are brought up in a higher number in our society. Of course, from a political point of view, we could raise the question of solidarity. We could raise the question of solidarity to say, isn't it a question of solidarity that the people that have become this vaccination, that they say, okay, I accept the restriction that others also have to accept. This is an idea, but the conception of fundamental rights under our institution didn't know the limitation of solidarity as constitutional law factor, to be honest. There is the question, is this concrete restriction valid? Is it clear or is it not? So, and therefore, to bring a little bit a metaphorical example, if we have the discussion that we have two assemblies in Berlin, and one of the assemblies didn't or is illegal because of this or that reason, then we wouldn't say, from the point of solidarity, we would recommend the other assembly to say, okay, we stop our assembly now. So therefore, we must say it must be a clear view on the concrete circumstances. And if we look, for example, at the restrictions in meeting other people, there is no plausible reason if two people with vaccinations meet each other, and if it's from an evidence point of view clear that they couldn't infect each other. That's the question that we have to elaborate more. But if this question is clear, there is no reason for other restrictions in their fundamental rights. So from my point of view, this is not an automatism to say people that have become this vaccination, that they must suffer furthermore under the question or ongoing under the question of restrictions of their fundamental rights.
Thank you for this very current contribution to the discussion. We are almost out of time, but I will just going a few minutes over because there are just some more very interesting questions coming in. The next one is also related to the vaccine and the constitution. So do you think that the German government acted lawfully in delegating the purchasing of vaccines to the EU Commission without approval by Parliament? Did it thereby avoid accountability?
Yeah, I think the short answer is I think that they acted legally. The other question is whether this was, from a political perspective, the best decision. This is in hard decisions and in hard discussions at the moment. I think it's in core not a legal problem, because if we look at the discussions we had and at the points I've raised, for example, regarding Wesentlichkeitstheorie and regarding the proviso of parliament, I think it was not, from the constitutional point of view, it was not necessary to ask the parliament, because the question which companies were contracted to buy these vaccinations, this question was public, and the parliament could at every time pass a law or have a discussion about this topic. We had discussions about this topic in the last months. So this was, from a legal perspective, possible. So I think it's more a problem of the political perspective. And on the political dimension, I want to raise the point that I am, of course, a politician, and that's also the duty of the conservative parties, I guess, to have a pro-European point of view. And therefore, I think there are good reasons to say, okay, we face this situation with a common European approach.
Okay, and there's just one follow-up. So there has been quite, from your party, Markus Söder, but also from the Greens, greater debate about greater influence of the state over the production of vaccines in Germany. I think the US has introduced from their war production acts aspects to force more production within their country. Do you think that these steps would be necessary? And if yes, are they also legal?
So from a perspective of constitutional law, I think they are possible. They are possible with complicated conditions, of course, because if we look at the guarantees, at the freedoms of property and so on, or at the Eigentumsfreiheit, we say, if we look at these guarantees, it's obviously not possible without conditions, but the state could act like this. But at the current moment, we must ask us really skeptical whether this solves our problems, because we looked in the concrete situation in Germany that, for example, the companies BioNTech and Bayer found such an agreement, and it's in their own interest to maximize the production, and it's also in the interest of the companies that own the intellectual property about the production to maximize the production in some ways. And I would say, if we start a situation like this, and if we say, okay, with state decisions, we want to put companies through that, it is a long way, and it would also last definitely a couple of months, whether then this new started production is sufficiently in charge. And therefore, I'm a little bit skeptical whether this solves our problems, because all our points say at the moment that the companies are going through the summer in the situation that we have then, and I hope so, enough vaccinations to share with the people.
Thank you. And just one other question on Europe from Hannah Jager. I just summarize it very briefly. Maybe you can just offer us a quick response. It is on the border closures during the first lockdown. Why do we not stick together as a European Union in that regard? And do we not need a more European solution for the COVID crisis rather than nationals?
Yeah, that's a definitely valid point. And if I look back at the situation, I couldn't agree more. I couldn't agree more. This was not the Europe I wanted to see at this moment. And therefore, I'm more and more happy that we have now a common European approach in this phase, or in this phase of the pandemic. And it is not the really intelligent and smart solution to try to solve this crisis that affects the whole world, that affects us all. This didn't stop at borders. So with a view back, I think this wasn't the best decision, and therefore I could say I couldn't agree more.
Thank you. And just a very last question to wrap this session up. It is a more personal one. What irritated you the most during the last year as a member of parliament, and what surprised you in a positive way?
Well, it irritated me a little bit that I, who was formerly known more and more as only metaphorical, a little bit a hardliner in the discussions of how strong our state should act, that I am now in common with Sabine Leuthäuser-Schnarrenberger, the former Minister of Justice from the Liberals, yeah, because I was the one who said in these discussions, we must look at the decisions that the parliament must take. We must renegotiate some of the bases that are in our legal framework. And therefore, this surprises me a lot. It was sometimes a view from a different situation. But what was a positive point, if I look back, I think the parliament shows, even in troubling times, that we could work and that we know our responsibility, that we know our duty, that we know our constitutional duty. And therefore, of course, fear was, or yes, I think an unclear situation was among us here in the parliament. But we all looked forward, and I personally never lost the enthusiasm to fulfill the duties the Constitution had on us in this different and complex situations. And therefore, I must say, with some points saying, well, this or that could have been made better, but under all, I think the parliament played a good role. And I think the most important point is to take lessons from points that are not so good.
Great. I think that's a good way to end on this very positive note. And many thanks to you, Philipp, for this very interesting discussion. We hereby also conclude our official part of the third day of our symposium. Our LSE students can still expect more from you at our coffee chat later, and at our first pub quiz tonight, where you will ask some very interesting questions, and we're all anticipating your further participation in our event. So, but for now, thanks a lot, and thanks for asking and answering these important questions, and we all see you later.
Thank you, Maurice. Thank you to our listeners. I really enjoyed this discussion, and I hope to see you all personally in the next year at the next German Symposium. Thank you very much, and best wishes from the Parliament.
Thank you.